Hello and welcome to the next series of the Insolvency and Bankruptcy Code 2016. So the last episodes, last video, we have already seen about section 4, and we have also seen section 6. So you remember section 5 is the definition provision. Section 6 is the provision which states who can initiate a corporate insolvency resolution. And if you will remember, the chapter 2 is with regard to corporate insolvency resolution process. So now we are going to see section 7. Initiation of a corporate insolvency resolution process by a financial creditor. We have already seen that who can initiate a corporate insolvency resolution process. Section 6 says that a 3-person can initiate a corporate insolvency resolution process, and the financial creditor, and it is the financial creditor and operational creditor, and the process can also be initiated by a corporate debtor himself. So now we are going to see the provision with regard to initiation of corporate insolvency resolution process by financial creditor. So we have already seen who is a financial creditor, and we have to remember the definition is given for the financial creditors is given in section 5 clause 7, financial creditor, and clause 8 defines about what is a financial debt. Financial creditor is a person to whom a financial debt is owed. So first let us read through the provision, section 7. Headed initiation of corporate insolvency resolution process by financial creditor. 1. A financial creditor, either by itself or jointly with other financial creditors or any other person on behalf of the financial creditor, as may be notified by the central government, may file an application for initiating corporate insolvency resolution process against a corporate debtor before the adjudicating authority when a default has occurred. Explanation. For the purpose of this subsection, a default includes a default in respect of a financial debt owed not only to the applicant financial creditor but to any other financial creditor of the corporate debtor. 2. The financial creditor shall make an application under subsection 1 in such form and manner and accompanied by such fees as may be prescribed. 3. The financial creditor shall, along with the application, furnish a record of the default recorded with the information utility or such other record or evidence of default as may be specified. Subclause 3b. The name of the resolution professional proposed to act as an interim resolution professional, and C. Any other information as may be specified by the board. 4. The adjudicating authority shall within 14 days of the receipt of the application under a subsection 2 ascertain the existence of a default from the records of an information utility or on the basis of other evidence furnished by the financial creditor under subsection 3. There is also a proviso which has been included. It has been inserted by the Insolvency and Bankruptcy Code Amendment Act 2019, 26 of 2019, dated 5/8/2019, with effect from 16/8/2019. Wide S4 2953E, dated 16/8/2019. And the proviso to clause 4 reads, let me read the provision, provided that if the adjudicating authority has not ascertained the existence of default and passed an order under subsection 5 within such time, it shall record its reason in writing for the same. So next, the clause 5. Under the adjudicating authority, where the adjudicating authority is satisfied that a default has occurred and the application under subsection 2 is complete, and there is no discrepancy, disciplinary proceedings pending against the proposed resolution professional, it may by order admit such application, or b, default has not occurred or the application under subsection 2 is incomplete, or any disciplinary proceedings is pending against the proposed resolution professional, it may by order reject such application. There is also a proviso to the clause, provided that the adjudicating authority shall, before rejecting the application under clause B of subsection 5, shall give it it gives a notice to the applicant to rectify the defect in his application within 7 days of the receipt of such notice from the adjudicating authority. The corporate insolvency resolution process shall commence from the date of admission of the application under subsection 5. 7. Adjudicating authority shall communicate the order under clause A of subsection B of to the financial creditor and the operational debtor. And the order under B, the order under clause B and subclause B of clause 7, the order under clause B of subsection 5 to the financial creditor within 7 days of admission or rejection of such application, as the case may be. Let us look at in depth into the provision. So here it says about the initiation of corporate insolvency by a financial creditor. It says financial creditor either by itself or jointly with other financial creditors. With other financial creditors or either by himself, may file an application for initiating the corporate insolvency resolution process against a corporate debtor, the person who is due the amount, before the adjudicating authority when a default has occurred. So there must necessarily be a default by a corporate debtor for initiation of the corporate insolvency process, and the corporate debtor either by himself or jointly with other corporate creditors can file an application before the adjudicating authority. Here, with regard to this section, for these words with other financial creditors, there is a amendment by which there is a substitution for these words other financial creditors by the Insolvency and Bankruptcy Code Second Amendment Act 2018, 26 of 2018, dated 17/8/2018 with effect from 6/6/2018. The words has been inserted, and now this subclause reads as a financial creditor either by itself or jointly with other financial creditors or any other person on behalf of the financial creditor. Any person on behalf of the financial creditor can also jointly file an application. It reads as or any other person on behalf of the financial creditor as may be notified by the central government. So the words that has been substituted is other financial creditors or any other person on behalf of the financial creditor as may be notified by the central government. Here we have to look into the definition of adjudicating authority. Section 5, which gives definition for the terms that are defined in this chapter, says about adjudicating authority. Section 5 subclause 1 says that adjudicating authority for the purpose of this part. So, the part of insolvency, resolution and liquidation for corporate personals means National Company Law Tribunal constituted under Section 408 of the Companies Act 2013. So, this is the meaning of the adjudicating authority. So, now coming back to the section, the explanation that is appended to this section: for the purpose of this subsection, a default includes a default in respect of a financial debt owed not only to the applicant financial creditor but to any other financial creditor of the corporate debtor. So, default includes not only in respect of the financial debt owed to the applicant but also any other financial creditor by the corporate debtor. So, as we have already seen the definition of debt, which is given in section 3, clause 11. The continuing further clause 2 says, first says that the application can be made by the financial creditor by himself or jointly, and the second says that the application which is to be given under clause 1 shall be in such form and manner as may be prescribed and accompanied by the fee prescribed. So, that is given in clause 2. Clause 3 says the financial creditor shall, along with the application, should furnish these following A, B and C related details. To furnish, first A record of default recorded in the information utility or such other record or evidence of default as may be specified. So, it should specify the records with relate to the default, and it should or evidence with regard to the default. Second, the name of the resolution professional proposed to act as an interim resolution professional. This we will see in detail from in the subsequent sections. We will say the application should also give details about the default and also about the name of the resolution professionals who will act as an interim resolution professional, and any other information as may be specified by the board. So these are the details that should be included in the application. Next, the adjudicating authority shall, within 14 days of the receipt of the application under subsection 2, ascertain the existence of the default from the records of the information utility or on the basis of other evidence furnished by the financial creditor under subsection 3. So here the time limit of 14 days has been prescribed in the Act. This should be noted. And next subclause, where the adjudicating authority is satisfied, he should satisfy himself about the existence of the default, and where he is satisfied that a default has occurred and the applicant application under subsection 2 is complete, then and there is no disciplinary proceedings pending against the resolution professional. So in the earlier clause we have seen that a professional has to be named who shall act as a interim resolution professional, and there should not be any disciplinary, the adjudicating authority will ensure whether there is any disciplinary proceedings pending against him, and if it is satisfied that no disciplinary proceedings is pending against the resolution professional, it may by order admit such application. Or where there is or default has not occurred, or the application is incomplete, or any disciplinary proceedings is pending against the proposed resolution professional, it may by order reject such application. So these are the two subsequent actions that will be taken by the adjudicating authority after submission of the application. So there is also a proviso clause. So before that, in clause 4 there is also a proviso clause which has been inserted by the Insolvency and Bankruptcy Code Amendment Act 2019, 26 of 2019, dated 5/8/2019, with effect from 16/8/2019. So the proviso reads, provided that if the adjudicating authority has not ascertained the existence of default and pass an order under subsection 5 within such time, it shall record its reason in writing for the same. So the adjudicating authority should dispose of the application either to accept it or reject it within 14 days. If he does not do so, he must give a reason in writing, that is the proviso. So coming back to clause 5, the proviso reads, provided that the adjudicating authority shall, before rejecting the application under clause B of subsection 5, so where there is it satisfies itself that there is no default and or the application is incorrect or any disciplinary proceedings is pending, it should give notice to the applicant to rectify the defect in his application within 7 days of the receipt of such notice from the adjudicating authority. So 7 days will be given for rectification of the defect in the application. So after the proviso, so now continuing further, clause 6, the corporate insolvency resolution process shall commence from the date of admission of the application under subsection 5. Clause 7, the adjudicating authority shall communicate an order under clause A of subsection 5 to the financial creditor and the corporate debtor. B. The order under clause B of subsection 5 to the financial creditor. So here a subsection 5 clause A is where he admits the application, then an order of the same shall be communicated both to the financial creditor and the corporate creditor. When an application has been rejected, the same shall be communicated by order to the financial creditor. So that concludes the section 7, and there is an important amendment with regard to provision in section 7(1). There is a provision that has been added by amendment that we will also look into now. So here the amendment, this provision has been added. So provided that for the financial creditor referred to in clause A and B of subsection 6A of section 21, an application for initiating corporate insolvency resolution process against the corporate debtor shall be filed jointly by not less than 100 of such creditors in the same class, or not less than 10% of the total number of such creditors in the same class, whichever is less. Second provision is provided further that for the financial creditors who are the allottees under the real estate project, an application for initiating the corporate insolvency resolution process against the corporate debtor shall be filed jointly by not less than 100%, not less than 100 of such allottees under the same real estate project, or not less than 10% of the total number of such allottees under the same real estate project, whichever is less. Next, provided also that where an application for initiating the corporate insolvency resolution process against the corporate debtor has been filed by a financial creditor referred to in the first and second proviso and has not been admitted by the adjudicating authority for the before the commencement of the Insolvency and Bankruptcy Code Amendment Act 2020, such application shall be modified to comply with the requirements of the first or second proviso within 30 days of the commencement of the said act, failing which the application shall be deemed to be withdrawn before its admission. So these has been added, and the same is inserted by Act 1 of 2020 with effect from 28/12 2019. So this is also included in the recent syllabus of the limited insolvency examination. So this amendment has also been read for the exam. So that concludes the section 7, and we will see we will continue the provisions in our next video. Thank you.